Well, good morning, everybody. We're going to be going over the NABOR listing contract today and a few of the amendments addendum to it. And we're going to take it right from Form Simplicity, so you know there's nothing monkeying around here. This is right off Form Simplicity, so anybody has any questions. And this is a big deal because this is how you guys make sure you get paid. So we're going to start with one thing about the NABOR contracts that everybody needs to be aware of. Of course, you probably are already. As almost every form in the NABOR forms, the lines are numbered. It makes it real easy to talk to somebody about whatever line you're going to talk to. We got a few amendments and addenda that are not numbered, but almost everything is. So one thing about this document is that it really tracks the sales contract, so it's pretty easy to follow. If you go through your customer with this form, they're then prepared for the sales contract when they do get a sales contract, which you guys will bring into them almost right away, right? As soon as it's listed. Okay. So we start with the, and this is the most important thing that I'm going to go over today, and this is something that they didn't used to teach in Naples, but they really focus on it since I was beaten on it, and that's line 3, seller. Okay, so the seller, this is where you're going to put down the owner of the property, and you need to be sure that you get all of the owners and anybody that has the necessary authority to sell the property. You need them to sign the listing contract. And I go over that when I teach sales contracts because we teach that a lot more often. I say you got to get the seller right, because if you don't, you may have a contract that's going to be unenforceable. But right here on line 3, that's the time you want to look it up on the property appraiser's website. You want to find out how is the title. Remember, the property appraiser's website updates based on last recorded deeds. Doesn't update based upon divorces, which also vest title. Doesn't update based upon probate. Doesn't update anything else. So there's other ways to obtain title other than the last recorded deed. So you want to look, at least find the last recorded deed. And this is the time, as hard as that may be to believe, this is a time where you may need to talk to the attorney, because if you've got an LLC, if you've got a trust, if you've got a corporation, if you've got a South American corporation, whatever you've got that's other than a living, breathing United States citizen resident, okay, you want to be sure that you're getting someone that's signing this listing contract with the authority to sell the property, because if you don't, then you may have a hard time getting a commission or even getting a sales contract later on. Everybody understands that part? Okay, the broker, I'm assuming you guys can figure that line out. That is not your name, okay? That is the brokerage. As you know, or should know, the listings belong to the broker, so the broker name goes there. Okay, then we move on. Lines 5 through 11 are word for word what's in the sales contract. So we go through and we define line 5 to 6, basically the real property and the landscaping, which is defined as landscaping. Then all non-leased fixtures and the landscaping are real property. You need to go over these things with your seller. I know that you probably do that, but I just want to reiterate that. These things go wrong. Sellers take plants with them. Sellers will tear up the royal palms that are in the yard because they're valuable. And you need to be careful with that. I found out last night I lost an aloe plant somewhere along the road. It was went out to get some for a sunburn, and the whole plant's gone. So I don't know where it went. Could have died. I think that's unlikely. I think aloe plants are almost impossible to kill. But this is the kind of thing that happens. So if you had a giant aloe plant outside, that might disappear after the listing. Got to remind your seller everything stays. Okay, then the rest of these items that are in lines 7 through 9, home automatium, audiovisual, hurricane storm shutters. We added something in here that both the shutters inside and outside, because I found in Naples has all these problems we never have on Marco. But in Naples, they steal the drapery rods, and they also take the plantation shutters off of the windows from time to time. And those things are what prompt contract revisions when we sit down and go through the bind. And I sit there and I'm going, we're going to put drapery rods in as a listed item. Why do we have to do that? And they tell me because people are taking the drapery rods. And I'm like, okay, we'll put it in. So all of these items, water softener, purification. So you can see these are things that you probably haven't had a problem with, but I can assure you someone has. That's why they're in here. So we've listed the items that when we have one that comes up
People say, yeah, that seems to be the trend, and I could see someone taking a water softener system out of a house. But all that stuff stays, okay? And then anything else that's going to stay goes into line 12, and those are basically removable fixture type items, okay? So that's not the personal property that's going to be there. And all of that is defined again as the real property, which remember is the landscaping and the fixtures and the improvements, and these items here, that's called the property, okay? And then the next line, 13 through 16, that's the personal property that's supposed to stay. And one of the things to remember, washers, dryer stays. All refrigerators, and S's on all of these. The contract, the land of the listing agreement later says plural means singular, singular means plural. So you don't have to put S's on all these because we already say that if there's not an S, it includes everything, as if there was an S. But there's an S on all of those words for a reason. That's because people will take out things. And you have to be careful because folks will take the refrigerator in the garage. It's supposed to stay. They need to understand that if they're planning on taking it, they may have a beer cooler that they've got out there that they want to take with them. It's really not something except that they just got it. It's in the garage. So if those things are going to stay, then you need to list those, and you put those in. You put those as an exception down here on line 24, okay? Then on line 17, just like the sales contract, you add anything else that's going to stay. And then personal property, which is there. And it's going to, the listing is then going to be there for a period of time from the commencement date and terminating on the blank date. So what's the typical number of days we can't really talk about in this class, but you want to have enough time so you can market it. When I'm talking to my clients, they want to list with a realtor, and they say, well, gee, I don't know, this period seems like an awful long time. I want y'all to have at least 6 months, but I want you at least get through season. And I tell them that. You need to have an opportunity to sell, okay? Now, if nothing's filled in, line 21 says the termination is 270 days from the commencement date, okay? So the form itself has a deadline for it. Doesn't mean you leave these dates blank. I mean, you should still fill them in, as we talk about all the time in contracts. Anytime there's a blank in a contract, you want to fill it in because your customer is going to look at the filled in blanks and isn't going to read much of the rest of this, okay? Again, line 24, that's what's excluded, okay? Now, one thing to keep in mind on furniture and furnishings, and remember, whatever I offer you is advice, subject to your broker saying it's good advice. But appraisers look at listings when they go in to determine what the property is worth. And if they go into MLS and they see that it was offered furnished, they report that back to the lender. They report that back to the lender. Lender may ask a question. If lender finds out furnishings are being sold with the property as part of the sale price, you may have a problem with financing. And although 30% of your deals are financed, that's still 30% of your deals. So my suggestion, when you put it into MLS, is to put furnishings negotiable. That's my suggestion. Talk to your broker. If your broker likes that, you may want to do it. We know in this market that almost all residential property sells furnished. So furnishing negotiable is kind of a password that the furnishings are included. You just need to ask. Okay, but if you put in their furniture included, completely furnished, I mean, that could be a problem for you on a finance transaction, so you don't want to do that. Okay? Lines 25 through 29, this is a good discussion to have with your customer. Property interest, seller represents, seller owns the property or has an equitable interest or proprietary interest. Okay? These things can come up in respect to probate, for example. If it's homestead property, homestead is not an asset of an estate unless it is conveyed to someone in the will other than an heir. So homestead property is not subject to probate as a general rule. But as soon as the owner of homestead property dies, whoever's supposed to own it owns it. They have an ownership interest in it. Are they on legal title? No. But they have an interest that they can sell. So if you get a listing contract signed by a personal representative, and it's homestead property, and under Florida Constitution, there are limits on what somebody can do insofar as putting in a will who gets their property when they die if it's homestead, and you don't have the heirs who are going to get that property sign the listing contract, you may not have an enforceable contract. Okay? Now, I'm not going to tell you that's a problem. I haven't seen that be a problem in my practice, but I can tell you from a legal perspective, we have to get those, and you've probably seen it in your closings, we have to get those heirs to sign the deed because they have an ownership interest immediately upon the death of the owner of the property. Now, if they didn't sign the listing contract and we go to them, and I have had this problem, We go, we need you to sign this deed. And they're unhappy. They don't like the sale price. They didn't want the furniture to be included. Are they going to sign the deed? That's the problem that we have, okay? So if you don't get those folks to sign the listing contract, and then we go to sell, you don't have the ability to sue them. The buyer doesn't have the ability to sue those folks who didn't sign the listing contract because they didn't sign the listing agreement. I have a little problem suing someone just based on the signed listing agreement, but where's your commission going to come from? You can probably sue the executor, the personal representative, because the person signed and says that they have the interest in the property to be sold, but from a realistic perspective, they don't have all of the interest in the property to be sold, okay? Same thing with a trustee. Just because it's in a trust, somebody dies, homestead property, people are going to inherit it. As long as they're heirs, they have an immediate ownership interest as soon as that person dies. You get the trustee to sign the contract, to sign the listing. We still have to go to those people who are going to inherit the property, even if they're not on the title, even if they haven't been conveyed the property, and they have to sign off on the deed because of their ownership interest. Everybody understand that? So it gets complicated. We can't just look it up on the property appraiser's website and say, oh, I see Joe owns it or Joe's dead. Who's the trustee now? That's a great first step, but doesn't necessarily get you home. Okay? Lines 30 and 31, again, this follows the sales contract. This is what the seller has exclusive right to use and is selling: parking space, garages, cabanas, storage lockers, boat docks, or slips. We put down the designation number, not the number of them, so it's like B2 instead of 2 parking spaces. And that's important to get this right, as we talk about, and I keep saying that. A lot of those items that are up there, the seller can actually sell to somebody else. Doesn't have to go with the unit. They're usually limited common elements, so they will go with the unit. But if the seller is not going to sell them or is planning on selling them, we have had people that have had 2 covered parking spaces, and they're only going to sell 1. Only one's going with the unit. Okay, this is when you want to find that out. Okay, because if they go ahead and close on sale of the unit, whatever they had as a limited common element goes with the unit. Later on, they think they're going to sell whatever it was they were going to keep to someone else, and they can't do it because they just sold it. Yes, ma'am.
Company and then divvy out to the next person on the list. So it's important to talk to management too.
Well, that'd be a question of she said that at South Seas East, was it?
Yeah, they're not doing it right now, but there's a new person that's in there, and he said they could change it. The board could vote to, because it's not really clear in the board of director or the minutes or the
Okay, so she's saying that at South Seas East, maybe in some other condominiums, that the board of directors can take back a covered parking space or a cabana or something. And that might be true and be subject to the declaration of condominium. But in many of these condos, people get assigned the right to use something by the board. It's not a limited common element, it's just a use right. So it's in the nature of a lease. Okay, boat slips are that way in a lot of these condos. Okay, they get in line, they line up, they sign up, they get to use the boat slip, and then if that person sells the unit, doesn't go with the unit, somebody next in the line on the waiting list gets to use the boat slip, okay? This is the time to figure that out, right? Because the last thing you need to do is to put it out in MLS and have a buyer come in and they think they're getting a boat slip, for example, and they're not. It doesn't go with the unit. So that's the converse of my problem, which I usually find, which the seller comes back into me after the closing and says, okay, I've got a buyer for my boat slip now. I need you to write up a contract and close me on a boat slip. And I go, you don't have a boat slip anymore. You sold your unit and went with the unit. Okay, so you've got the opposite. You've got one where the person doesn't even own the boat slip, doesn't go with the unit. It's a lease type arrangement, or what they try to call it as some type of a license or right to use, because when they lease it, it's a rental. They have to pay money to the state because it's a submerged land lease. So a lot of the condos try to get cute and pretend like it's not a lease, it's just a use, whatever it might be. But that's something that's real important, and often your owners listing don't know the difference between owning the boat slip and merely having a right to use it, because it's a common element which, under the rules of the condo, they allow people to use if they sign up and then become available. And I'm going through that right now with an association. They're battling it out over how they're dealing with those issues. Okay, because it also becomes important as to who pays to take care of the boat slips. It's a limited common element. the declaration can make the owners responsible. But if not, then the whole association is responsible. So that's a good point you bring up. Okay? All right. So we move on. We're going to put the property legal, the property address, the property tax identification number. I keep saying we need to get all of those in here. They're not hard to get because if you make a mistake with one, we've still got a good listing contract. If you only put one in and you make a mistake, you don't have a listing agreement. So get it right here, and then hopefully we'll get it right on the sales contract, and we'll be able to close and get commissions dispersed. Okay. 37 at E, and this is a place where you can talk to your customers and really help end run some problems that we have. Some folks believe that all the money that's in a fully funded reserve account is their money and they should be able to take it when they leave. And they raise Cain about that. Okay? So this is the time to explain. In fact, we're working on contract revisions right now. That's one of the issues that we're trying to address in the sales contract to make it clearer. Reserve accounts go with the unit. That's like a common element. Whatever's in the reserve accounts, it belongs to all of the property and not to the unit owner. We have problems here sometimes with special assessments where they paid it in or the payments aren't due or they're not due till later. The owner thinks they get it back. So this is the time when you're taking the listing to have that discussion. Make sure they understand here's the way it works. Okay? And if they don't understand it, that may be not your discussion. Maybe that's the lawyer's discussion. So when you're taking the listing, not a bad time to have the lawyer involved. Say, explain these things because I don't want to be the bad guy that says you don't get to keep all that money that's there. And in fully funded, we're going to see that more and more. We're going to see two problems as condos progress. Now that we have the studies to make sure they're structurally sound, we're going to have some substantial assessments in order to get buildings into structural soundness. And we're also going to have increasing amounts of money in reserve accounts because they can no longer waive structural integrity items for reserve funding. Okay, so whereas a lot of them would waive them in the past, say, well, you know, I'm not going to live long enough to need a new roof on this condominium. I don't want to pay to replace the roof. Well, they're not going to be allowed to do that anymore. No matter how long they're expected to live, they're going to have to fully fund those reserve accounts. Okay, and that's going to be a lot. So we're going to have some catch-up reserves going on because if it's a roof item, for example. How long is the roof going to last? 20 years? And if there's currently no reserve for the roof and it's 15 years old, over the next 5 years, they've got to put away enough to replace the roof. That's a pretty substantial reserve item. So I think we're going to see a lot of these condos are going to have some big spikes in the assessments, and I think that may affect marketability. Yes?
Why is that there?
Why is that there?
Yeah, why is reserve account balance there?
So you can have this discussion. It's exactly why it's there.
Just a point of discussion.
Well, also because they do go. I mean, they go by law anyway. But you know, why is anything else in here? All these items up here that I just told you we added with S's because they walk off, and they're supposed to be included. Okay. So reserve account balances, they stay. They're part of the unit. So the owner needs to know that. So it's there not only because it gives you guys the opportunity to talk about it, but it's there because that's the law. So if we go back later and somebody says, hey, I wanted that money. Well, they're going to go back and say, well, your listing contract points out that it stays, and it's in the sales contract as well. So I don't think you don't want to have that discussion with your owners because since it's here and it's in the listing and it's in the sales contract, the last thing you want to do is have somebody go, well, why didn't you tell me about that? I think people don't like surprises, especially when they're bad, right? Okay. All right. So moving on, listing price and terms. So line 39, the exclusive right and authority to sell shall be for the following listing price, okay, or upon any other price in terms or exchange to which seller may hereafter consent. So you're looking for a right to compensation because you brought a ready, willing, and able buyer. This is the price on line 39. If you bring in a cash offer at that number, you have earned your commission. If the seller refuses to accept it, you have the opportunity to collect a commission nonetheless. Okay? Anything less, the seller can accept. The seller does accept something less. Once again, you have brought, as long as a ready, willing, able buyer, you have once again earned your commission as of that time. And if the seller defaults, your commission right doesn't go away. Okay. Line 41, broker's obligations. And again, this to me is a great sales tool when you make a listing presentation because if you go through all these things, these are the things you're going to do. become informed about the property, make an earnest and continuing effort to sell the property. However, the listing contract does not guarantee such efforts will result in a sale. Now, in a slower market, the one complaint I hear is my realtor didn't do anything. Okay? I usually think it's untrue that the realtor didn't do anything, but I think one thing the realtor didn't do was keep the customer informed about what the realtor was doing. Okay? So, something you need to do. Promote the property as the broker deems appropriate. Okay? To keep the seller informed as to broker's efforts. Okay, that's a big deal. Take reasonable precautions to prevent damage in the process of showing the property or permitting others to show the property, and distribute information that the broker deems appropriate. So here, you're the marketing expert. And all the language in here says it's up to you. It's up to the broker. Whatever the broker deems appropriate, that's going to be done. Okay, so if your seller is expecting something else, you do listing presentations. I don't, but isn't that the time to find out what your seller is expecting? What are you going to provide? I think you need to make that really clear, because this just says you're going to do these things that your broker deems appropriate. So you're going to put an ad in the paper every week, full page? I don't think so. Your customer needs to understand that, okay? All right? Now, next we get into little things that become a little bit more difficult. Line 53, if no selection is made, one applies. Shall enter the property in the MLS within 5 business days of the commencement date or 1 business day after public marketing. And public marketing means the first moment that it is offered for sale to anyone other than you. So even internally in your brokerage firm, you've done that. That's out there. So that's got to go into MLS then promptly after that. And Peggy, thank you for bringing donuts. So anybody that wants a donut, we have some in the back of the room. Okay. Or shall not enter into MLS. Okay. And if 2 is selected, the broker cannot market the property outside of the broker's office, including but not limited to all these different things that you can do. So if it's not an MLS, you can't market it. Okay. H, the broker shall or shall not disclose the existence of offers on the property to buyers or cooperating brokers. If disclosure is authorized and asked, broker shall disclose whether the offers were obtained by the listing licensee, another licensee of broker, or a cooperating broker. So everybody understands that? Any questions on that paragraph? You all are in the business. Any customers ever had any issues with this? They want you to disclose, not disclose? Okay. Internet options. Seller agrees property may or may not be displayed on the internet. So if you don't check a box, it's going to be on the internet. I find, at least from my hearing from people, that there are an increasing number of people who don't want their property on the internet, even though it might sell, because of security issues. Okay, they all think that when somebody finds out the house is for sale and they're up north, that they'll end up with a squatter, or the furniture will be all gone, or someone will vandalize it. Okay, so be anticipating some pushback on that if you prefer to put it in there. Okay, and then seller acknowledges that if 2 is selected, consumers who search the internet will not see information about the property in response to their search. Seller selects 1. Seller first agrees that address of the property may or may not be displayed. Okay, again, pushback from some folks. Brokers or selling licensees participating in or subscribing to MLS who operate internet websites accessible to their customers may or may not display an automated estimated valuation of the property on the websites, and may or may not enable users to post comments or reviews. Y'all know what happens with comments or reviews. Okay, so I'll leave to you as to whether you check which box. Okay. 70, we have the same issue with security with some of our folks, but you can use a lockbox. You have to check does or does not authorize the use of a lockbox. Okay. Realtors are convinced lockboxes are very secure. Customers are not. Okay. We know when they're accessed. We know who's accessing them. So we think we got a pretty good grip on that. Customers not so much. Okay. Yes?
Some of the condo units now are using the digital or the touch screen locks on the doors. So there's no place to hang a lockbox. I don't know if that's worth putting in there down the road or not.
You know, that's a good issue. They question about some places don't have doorknobs, what we're talking about. So there's no place to hang a lockbox. That may change the industry. But, yeah, That's a good issue. I'll take that to legal resources. We're going through that right now. So, well, I think the condo might be a little unhappy with that, but that may be a possibility. But that's a good issue. Good question. Okay. But if it is that way, what do we put in the lockbox? The code to get in?
No, you can call and give them a code. It's good for, at least in our case, for an hour, 2 hours, a week. You just keep changing the codes to whoever's going to go show the property.
Okay, is this a lockbox code or the code to the unit itself?
The code is, yeah, the touch screen.
Okay. All right, so you don't really need a lockbox if they don't have a doorknob then, because you've got the electronic and you change it. Okay. All right. So we've got that the lockbox is intended to facilitate marketing. This line is important. The seller releases the broker, any real estate association or MLS, and any members, participants, or subscribers for any injuries, losses, expenses, or costs incurred by the seller by reason of unauthorized access to the property from use of the lockbox. Everybody get that? Okay, right now, my understanding is on MLS, the only authorized users of lockboxes are the licensed agents. Not the assistants, not the bugman, not the home inspector, which means you have to accompany these folks when they go through, okay? Brokerage relationship at K. Broker has informed, disclosed the seller of the brokerage relationship between broker and the seller. Broker's required disclosure notices have been provided, and the brokerage relationship is blank. And if left blank, transaction broker. Now we know that's the default in Florida. So if you're going to be a single agent, you definitely need to fill this in. But I think that's a great time to explain transaction brokerage because we've still got a lot of issues, especially out of the Stinson-Burnett case and antitrust and about who you are and what you're doing. And buyers think that you're representing them when you're a transaction broker. That's not necessarily the case. Okay? So we need to make sure at this point, from a legal perspective, a transaction brokerage, at least while we have that in Florida, it's explained if that's what the default's going to be. And it is for 99% of the agents in the state. The brokerage firms want that because they don't want you to have to transition from a single agent to transaction over show property that's listed by your broker. Okay. Okay, this says at next 80, the broker, any cooperating broker or legally authorized escrow agent is authorized to accept and hold in escrow all deposit monies, and the duties of the escrow agent shall be in accordance with the state of Florida and regulations of Florida Real Estate Commission. And those are different for brokers than they are for attorneys because you have to do things with your escrow account that I don't necessarily have to do with my trust account, including I don't have to tell people. I'm not required to tell anybody if I get a deposit. Brokers are. Okay, so I'm not subject to the Florida Real Estate Commission regulations. Now, we do it as a matter of course, but don't have to. So if you do have an attorney, it's not cooperative. I want you to understand, attorney's not stuck with that rule that they have to tell whether or not the deposit is there or to even deposit it. Okay, now, ethically, I have to deposit it because I got to have the money. It's got to be collected. But I'm not stuck with a FREC rule. Okay. Seller's obligations, and this is something that you look at and it kind of parallels what you would tell to someone about if you're going to be get a buyer brokerage listing agreement. To refer immediately to the broker all inquiries about the property, whether those are from other brokers or any other persons or entities. How do you sell that to somebody? They have a duty. This is the seller now has a duty to you to refer everybody to you. Yes? Okay. To provide broker or those working buyer through the broker access to any improvements. Okay. Now, 90 is a big deal, and it's really in there because this form is done by a trade association to protect public and, importantly, to protect you. Seller has a duty under line 90 to inspect the property from time to time and prior to any scheduled inspections and presentations. How many sellers do that? Okay. To detect and remove any safety hazards or unsafe conditions and to otherwise take all reasonable actions and precautions to minimize risk of injury to the broker, cooperating brokers, prospective purchasers, authorized agents. The broker shall not be liable to the seller for any personal injury, losses, or damage suffered by any of those parties. And the seller will hold the broker harmless and indemnify the broker. That's pretty good language. It puts it on the seller's responsibility to make sure the property is safe. How many sellers appreciate that and want to blame the broker as having responsibility to make sure that the property is safe? Okay. To comply with statutory and regulatory disclosure requirements, now as a general rule, you try to do that. You know we've got the energy efficiency brochure that you have to provide in every transaction. If it's a pre-78, you've got lead paint disclosure that you've got to provide in every transaction. Those are seller obligations. All right. Seller is going to have to give at line 171, deliver the possession and occupancy of the property on the closing date. Please make sure your sellers understand that. Some people in the Midwest, the practice in the Midwest in some areas is they don't move out till after closing. Okay, so if your seller is under the belief that that's what the seller is going to do, there'll be a brouhaha at closing, and it probably won't bode well for you, me, or anybody else involved with the transaction. So be sure they understand they need to be out when they come to the closing. Then we're going to prorate real and personal property taxes. And I'm not going to go through this whole paragraph because I don't think you need to be experts on how we prorate everything, but we do prorate the property taxes. From my perspective, I think the best thing for you to do is remind your sellers that we pay our taxes in arrears. And same thing, right? Taxes are in arrears, right? Mortgages are not in advance, they're in arrears too. So when you're paying interest for that month. So sellers need to know that because a lot of them think that when they pay their mortgage payment, it's like rent. They're paying it for the following month and they get money back. It doesn't work that way, and we have to spend a lot of time explaining it. Get the banker to explain it, make sure they understand it. The tax proration thing is even a bigger deal. They think they're going to get a big refund because they just paid the tax bill, and it turns out they didn't pay it for this year, they paid it for last year, okay? So be sure they understand that because I don't think there's a problem if they understand it. But I think if you don't remind them that's how it works here, they get upset. And if they get upset, they just take it down on everybody. And I don't want y'all to lose business because they're mad at you, okay? And so then we move on at 183, that the seller is to grant the buyer a credit equivalent to the amount of any security deposit that a tenant has and any prepaid rents. So we're going to prorate rents as well. And if there's a security deposit up, that goes over, and that's a credit to the buyer because that's going to have to go back to the tenant anyway. That's not the seller's. Seller disclosures. A, seller represents and warrants that to the best of seller's knowledge, no other party has a legal or equitable ownership. So you see that's in here twice, so that's a big deal. B, the seller acknowledges and understands that the seller knows of no facts or conditions materially affecting the value of the property which are not readily observable. Seller has an obligation to disclose all such facts and conditions to a buyer and to broker. All such known facts and conditions shall be set forth in writing in other terms and conditions or by written document attached hereto and presented at the time of execution. Now that's important because if there is anything, this is a great paragraph to make sure you talk to your customer about, because if your customer gives you any information about this and you write it down, the customer writes it down on a seller disclosure, and you give that to the buyer before the buyer signs the contract or counteroffer, then whatever it is that's been disclosed is not something the buyer can complain about after they do a home inspection. So everybody understands that. So if it's a defect, if it's a leaky roof, whatever it might be, the generator doesn't work, the pool heater doesn't work, whatever it might be, if that's disclosed to the buyer before the buyer signs the counteroffer or offer, then that is not, the sales contract says, that's not a defect that the buyer gets to complain about after the buyer does an inspection, because the buyer is buying with knowledge that there's a defect. And it's important that if the seller does comply with this, that you make sure you understand what those defects are, because you have also a duty to disclose material defects which are not readily observable. Okay? Which also makes it important that you become very familiar with your listings, because if you knew or should have known about a defective condition and don't disclose it, then you can be charged with having known of it and liable from a financial standpoint. Okay? My story about the sinking slab, I think most of you have heard it. The person was selling the house, had put boards underneath the carpet to bring it up to the baseboard level, toilet bowl brush in the corner of the bathroom. There was 4 to 6 inches of caulk between the tile and the tub. They did all kinds of things to hide that the slab was sinking. And my client bought it, and after we bought it, found out the slab was sinking, and I said, first thing I found, I went to the house, I said, well, there's this huge caulk between the tub and the tile in the bathroom. Didn't you notice that? And the guy said, yeah, I thought that's how they built houses down here. But the wood underneath the edge of the carpet and all that. So that's the only time I sued a realtor, and we got full compensation from my client, but there's no question in my mind the realtor, who was a licensed general contractor, was aware of the condition of the house. And somebody put boards underneath the carpet, so become familiar with the condition of the house, because I don't sue realtors, but the other attorney's happy to do so, so I don't want you on the wrong end. All right, so we've got seller acknowledges that known facts or conditions materially affecting are going to be disclosed. Then we go down to 197. Seller does or does not elect to complete a seller's disclosure form. They're not required under Florida law. Some brokers do require them. Has anybody ever read one that says anything other than I don't know? They do sometimes, but they're rare. Okay. So at least if you get one, you've done your due diligence, you've done your duty. 199, seller is or is not a foreign person or entity as defined in the Internal Revenue Code. The seller is a foreign person or entity. Seller may be subject to Internal Revenue Service withholding requirements. So this is the time for you to talk about FIRPTA. The listing contract does not address Florida's statute that requires buyers sign statements that they are not foreign nationals from Iran, South Korea, North Korea, the People's Republic of China, so the Venezuela government, Nicolas Maduro. So that's not in here because that's not a seller obligation, but I want you to keep that in your mind that you still got to do those. We got to get those signed. The only thing that's been placed on hold is the federal court issued a temporary injunction in connection with Chinese nationals, okay? Because those were the only individual plaintiffs in that lawsuit. They didn't have anybody from Syria, nobody from Iran, nobody from North Korea. So the Chinese plaintiffs in that case, the Chinese apparently domiciliary plaintiffs, they were successful in getting a temporary restraining order. That doesn't mean that the statute's going to get thrown out. It just means that for the temporary time, it's not enforceable against Chinese buyers. Okay? But the rest of the countries are, so we still do that. And the statute's still in effect. Okay? Yes?
Jump back to 187 for a second. I think if you have a seller disclosure, if you have a robust conversation with your seller, I think that seller disclosure is a valuable tool. I'll go far as to say I've talked to realtors who I agree with it. Go into an inspection company at the moment the house you have your listing and actually have an inspection company go into a thorough inspection of the property so that you can have your seller see exactly what they've got going on and maybe make some repairs to make it so much smoother for the transaction. I just think disclosure like that doesn't hurt you.
Well, there are some states that mandate that a seller have a professional inspection of their property as part of offering it for sale. Florida does not require that, obviously. They don't even require a disclosure form. But that's a broker by broker and a person by person approach. And having a property professionally inspected and fixing things that might be wrong with it certainly could be a sales tool, particularly in a slower market as opposed to one that's on fire and they'll buy anything. But that's definitely something to look at. It also helps to get the realtor off the hook because you've got an inspector, professional inspection company come in and turns up whatever it is, and those are all disclosed. It's pretty hard to argue that the realtor should know more than the professional inspector.
It's nice to show that repairs have already been done. I know one agent I know on the island actually pays out of her own pocket for the inspection done on the property. Being a cheapskate myself, I think I would maybe have a 50-50 conversation. So the outfit, it's about a $450 expense. If they would, I'll pay it.
Well, who's going to pay what is not a subject for our discussion, but that is something to talk about, and it's something that you can talk to the seller about. At the time of listing is some of the things that you think should be done. I think that's a great time to do it. Yes, ma'am.
There was a property that was owned by the agent. They were an Naples agent. They owned the Barco home. They put notes in the MLS, just in the notes section, and thought because they disclosed it in the MLS notes, there wasn't a seller disclosure, that they weren't responsible for those items. So
Okay, well,
they were wrong.
seller put in MLS, who was an agent, the disclosure items, thought they were off the hook on having to worry about them. And the sales contract itself actually says that the disclosure has to be in writing and has to be acknowledged by the buyer, which means buyer has to sign that the buyer got that on or before the date the buyer signs the offer or counter offer, as the case may be, before it became a binding contract. Okay, so putting it in MLS doesn't get there because you all know, because I say it all the time, whatever's in MLS isn't part of your contract anyway. So it's a good try to put it in there, and certainly shows that the realtor was trying to be proactive. So that may help keep the realtor out of liability because the realtor at least did that with it. But if there's a significant enough of an issue, what would that be? That needs a new roof, maybe, or something expensive. That would be a really big deal. That putting it in MLS may not get the realtor off the hook either. So keep that in mind. You have a duty to disclose, so it's important that you do that. Now, there is conflicting schools of thought on how far the realtor should go to check things out. So, for example, open permits. Realtors can go online and look for open permits. Okay, and I have heard that now once you find that, you have to tell the seller about it. Once the seller knows about it, the seller has to disclose, and if the seller doesn't, you have to disclose. So some people say ignorance might be bliss. You're creating more problems for your seller than your problem had before you came into the seller's life. But that's a decision for y'all to make. Okay? All right, so we're moving on. We're going to line 202. The seller shall provide a homeowners association disclosure summary to prospective buyers for each mandatory homeowners association as required by law. Now, you all are familiar with that. Sales contract has to have language in it that says that the buyer is entitled to that disclosure. Okay? And if it's not in the sales contract, then the contract is terminable by the buyer at any point in time, buyer other than by closing. Okay, the buyer can close and waive, but buyer can terminate any time. With the FAR contract, you have to attach a rider. With the NABOR contract, it's in the contract itself. So I kind of like that because that way we don't have to accidentally leave something off. But the Homeowner Association Disclosure Summary is a litigated issue that realtors help sellers goof up. First, you should not fill out the Homeowner's Disclosure Summary, because if you do, whatever you do in this wrong is on your shoulders, so whatever goes wrong is your problem. That's a seller obligation, or you can get it if hopefully the Homeowner Association would fill it out. But if the Homeowner Association Disclosure Summary is merely the numbers that you pay to that homeowner association that you have to pay, okay, that doesn't necessarily include the golf club that you are a member of. Okay, it doesn't include the condominium association, which is within the homeowners association. So the HOA disclosure form is only for the dollars that the property pays to that HOA. Okay, mandatory membership, mandatory payments. Everybody understands that. If you put anything else on that HOA disclosure form, it makes it incorrect, which then means it's the same as no form whatsoever, and the buyer has an unlimited amount of time. The buyer has 3 days from the day the buyer gets that form to terminate the transaction. And if you give the buyer the form before the buyer signs the offer or counter offer, the buyer has 0 days to terminate. This requires the seller to provide that, okay? So keep that in mind. That says the seller is supposed to provide it. So make the seller provide it. Don't take the liability. Okay, then 204, this is a big one too. Seller is or is not aware of any past casualty insurance claims made for damage to or for the property. That can be anything. You know, hurricanes roll through here past 20 years a few times. We got a lot of new roofs. I don't know if we can still get screen enclosures under insurance policies, but we got a lot of those for a while. Okay, we had a flood go through here, caused a lot of property damage recently. So those are all claims sellers might forget about, but they need to be disclosed. The big one that I see that becomes a problem under the past casualty losses is water leaks. Because insurance carriers all get access to those claims. And if there are enough claims for water leaks for a property, doesn't have to be a flood, but if there's enough claims, it becomes either uninsurable or insurable only at an extremely expensive rate. Okay, so this is a big deal that the seller provide that information. So make sure you ask that. Okay, lead-based paint, you know, if it's pre-78, then you need to have a lead-based paint disclosure. We don't have too much of that anymore, but you need to be aware that it's there. And at 209, if the property is located in unincorporated Collier County, which is everything outside of the city of Naples, city of Marco, city of Everglades, then the seller acknowledges receipt of the Collier County Code Compliance Residential Program brochure. If you go through this listing contract with your seller may ask you about this brochure. Is everybody here familiar with it? suspected that was the case. So the brochure was created about 20 years ago when Collier County said that they thought it'd be a good idea to have a Collier County inspector inspect every home that was sold to make sure that everything in the home had been properly permitted. Well, the Naples Chamber of Commerce and the Naples Board of Realtors didn't think that was a really good idea. Okay, and my kind of idea that I like small government rather than big government, I didn't think was a good idea either. So we went to work, and the ordinance, this is how far I got, the ordinance passed on first reading at Collier County. Okay, I understand to have an effective ordinance, it has to be read twice at a county commission meeting. So between the first reading and the next reading, which was delayed, with meetings with the county, the Naples Chamber, the Naples Board of Realtors convinced the county that if we provided this brochure that was developed jointly with the county in all the residential transactions outside of outside the cities, which is where the county has jurisdiction, then they wouldn't do the ordinance, and it never came back up for second reading. So I want you to be familiar with that. It is in the forms directory, so you can pull it up. It's a trifold. Fold it, printed on front and back. And it just talks about people should have the property inspected to make sure that all the things have been properly permitted. But I don't want the county monkeying around with this, and I don't think the county has brought it back up again. But I really want to be able to go back if the county ever decides to try to do that again and say, our folks are using the brochure and it's working very well. I fear that use has fallen off because the wolf is not at the door anymore. So I want you to know it's there, and the form is in the forms. Wherever you get your forms from, that form is there. Okay. 211, Community Development District, or MSTU. The property is or is not located within a CDD or MSTU. How many of your sellers know whether they're in a CDD or an MSTU? All of them, because they're really well informed, right? Okay, well, you know that's on the tax bill. You can look it up. You can figure it out for almost all of them. As far as your operation is concerned, Fiddler's is the biggest one locally, and then Hideaway has an MSTU for the beach renourishment. So those are there. Key Marco has one. It's not a real big one, but they have one too. And you go into Naples, they're just all up and down the county. So those are expense items, but you need to check it so that we know what they are, and that'll go into MLS. Okay, this says at 8, the seller will pay the full amount of any association, special assessment, and government liens or special assessments other than CDD MSTU, and that's because the contract says the buyer picks up the principal portion of a CDD MSTU assessment. So that makes it kind of like a sewer assessment. It passes on to the next owner. That's how people buy into Fiddler's. If they bought from it and they're still building out there, buy a new product out there, you buy subject to whatever the principal portion is of that assessment, and you inherit that. You pay that off like you do a sewer assessment. So the sales contract says the same thing from a second buyer to a third buyer. Okay. And anyway, this says that the seller is going to pay all the special assessments except for those which are on the effective date are a lien or a special assessment that is known as to the identity of the assessor, the property, and the amount. So if as of the effective date, that special assessment of the seller's, another good conversation to have, because sometimes those special assessments are payable over the next 12, 18 months. So we've got a big price, we got a big project, we're going to completely refix everything. Insurance did not pay, or there was an association in Naples that got a public adjuster, and they thought it was a great idea to go in and ask for everything that they could think of that the public adjuster could come up with, and they did, and they went to court when the carrier said, I don't think so, and the court said, that's fraud. A bunch of the stuff you're asking for wasn't even damaged in the storm, and they ended up with no insurance money at all. And they had to special assess, I think it was 1.4 million or 2.4 million or something on their condominium owners. So that's the problem, okay, special assessment. If that might be payable over the next 2 years, let's say, or 3 years, because it was going to be a project to repair a lot of things. There was a lot of damage to that condo. They had to repair a lot of things. It was going to take a long time, so they didn't need all the money today, just needed it over a period of time. Be aware that's all the seller's obligation if that's in effect on the effective date of the sales contract, okay? Okay, and then this goes on to say that if it was pending, pending, and it turns out to be more than 1% of the sales contract price, that's the gross price, then the buyer can back out of the sales contract unless the seller agrees to pay everything over 1%. So the listing contract puts that burden on the seller. Okay, that lays it out for you. Default, line 224, if the transaction is not closed because of the refusal, failure, or inability of seller to perform, or the seller fails or refuses, then the seller has to pay the compensation to the broker in full upon demand. Last line, if deposits are retained by the seller, half of the deposit, but not exceeding the amount the broker would get if the deal closed, it goes to the broker. Okay, everybody understands that? When we had the really hot market, I think I mentioned, I had the good fortune of being able to sue some sellers who decided that they would back out of their deals and just not pay a commission, and we got commissions in all of them. So those were fun. But the listing contract makes it clear that the seller has to pay you if they default, failure to perform. And they do that. Sometimes they have listings remorse. They decide they didn't want to sell at all. Okay. All right, litigation, attorney's fees and costs. I am happy to tell you I got this paragraph put in last time we revised this. This was not in there before, but after suing people for commissions, I said, we got to have a clause in there that says we're going to get attorney's fees because I don't think that the seller is going to sue a realtor under the listing contract because this is a compensation contract. So who's going to sue who? It's going to be the broker suing the seller if they ever want to do that. Some of them don't, but those that do, I think they ought to get their attorney's fees. So this is a time where the contract itself should have attorney's fee clause in it because it's going to benefit the broker, because the broker is going to be the one suing for compensation, so they ought to get made whole. They do that by attorney's fees as well. Okay, so this miscellaneous property shall be offered, shown, and available so that you do not violate federal law or NAR. NAR's Code of Ethics is broader than the Federal Fair Housing Act. So there's categories in NAR that are broader. I'm sure you're familiar with that, but you have to comply with that. At B, the laws of the state of Florida shall control interpretation. Makes sense, we're in Florida. C, listing contract constitutes the entire agreement between the parties. The listing contract is binding and enforceable upon execution by seller and broker, the effective date, which is the last date either the broker or the seller signs or initials the contract, right? Other terms and conditions. I don't have any offerings for you here. Yes, Jeff?
Are you writing all the legal stuff you want to add?
Yeah. Please, I say this every time I train. The more I practice, the more I say this. I didn't do when I was younger, but I do now. Anytime the blank takes more than a half a line, it's not a blank. It's a trap. So you don't want to write anything on those lines. If you're going to write something, get a lawyer to help you, or talk to your broker at least, and come up with if there's something to be put in there. And that might be where the seller wants to exclude Auntie Fran, who talked about maybe buying the condo, and if Auntie Fran buys it, then what are you going to do on the commission or whatever it's going to be? Okay, so that might be appropriate here. But other than that, I hate to put anything in there. Then we've got addenda. Now remember what we talked about if you all my contract class. Recent case came out and said that if you don't check the box, when there's a check the box on the contract form, and you're going to attach an addenda to it, if you don't check the box, it doesn't incorporate the addenda. Okay, so sales contract has check the boxes. This has check the boxes. We put them in the sales contract because the consensus, the majority consensus was, hey, we need to help realtors to know what they can add. So we'll give them the shopping list here at the bottom of all the addenda on the sales contract. So here you have this. If you don't check that, then you're not going to have it attached. Got the signatures. Get this filled out. And if you're sending something to an attorney to close it, give them all the information you have. Every once in a while, we'll get closing in, and we'll get the seller's name and maybe a phone number, but no email, and not the other seller's name. And so get us everything. Whoever you're going to send it to, give them everything they can, because we need to try to get a hold of these folks. And then if we can't reach you, and we can't reach them, and we need to get something, we don't have any way to get a hold of them. Okay. Then we've got the broker, and look, there's a place for the listing licensee. That's pretty cool, right? Everything else is a broker. Remember that. But this is your chance to shine right here. So don't forget to put your name there. Okay. Broker term. The wire fraud advisory. This is increasingly a problem. I think people in the industry may get immune to hearing this, but your customers don't, because they're not involved with wire fraud. So most brokers stopped taking deposits a long time ago. So if your brokerage firm doesn't take deposits, please be sure that your folks know you don't take deposits. And second, that you will never tell them anything about a wire, and I suggest you do that in writing, because there's just an amazing number of these that are still happening, probably more than ever. I get requests for things, and I mean, I can tell they're pretty bogus, but your customer won't be able to necessarily tell that. Be really careful with that. Okay. Okay, so we're done with the primary listing contract form. So this is a limited brokerage services addendum. So you know that you don't have to sign up to be a full service broker. And this may be a way when you're going to go talk to somebody and say, well, I'll do certain things. It's not going to be a complete brokerage arrangement. So the same information at the top, we've got the seller broker. Don't have to fill in all that stuff because this is an addendum, so we don't have to put all the information about the property identification. So we just put in the address, or you can put the legal here if it'll fit in. Okay. So in bold print, though, broker is retained and authorized by the seller to perform only those specific brokerage services checked below. None of the other services set forth in paragraph 3 of the listing contract. Any public marketing of the property shall require the property placed in MLS within 1 business day. So this is for limited brokerage service. So you have the options, pricing assistance. So you can do a market analysis, CMA. Anybody do those? Don't raise your hand, but if you do, here's the opportunity to do it. Also, we talk about in the listing contract what your compensation is going to be, right? Because you may want to make an adjustment for that. Advertise the property. Okay. Not check. Seller shall handle all advertising. Provide signage. Okay. Broker shall furnish seller with broker signage. Okay. Offer of cooperation, compensation to other brokers. Broker shall seek the cooperation of other brokers in procuring a buyer. MLS, broker shall enter the information on the property in the MLS and on related internet websites. Okay. Reciprocal broker websites, information on the property entered by broker in the MLS may also be displayed on the websites of other participating brokers. Open houses, broker may, as deemed appropriate, advertise and hold the property open for public viewing. Showing the property, broker shall show or allow cooperating brokers access. Now remember, this is an addendum to the listing contract, so the listing contract is going to lay out what the compensation is to the listing broker, and these are the services. So you're going to get rid of everything in the listing contract except for whatever's here. Okay. Lockbox, broker shall install a lockbox on the property. Present offers, broker shall receive and promptly present all purchase offers. Contract negotiation shall assist seller in negotiating offers or counteroffers. Transaction assistance assists seller in satisfying contract obligations to facilitate closing or other. Now, I don't know what to put on the line other because I'm not in the line of going out and listing property, but you do have an opportunity in that, and that breaks my rule of more than half a line, so it gives you the opportunity to make a mistake, so be careful with that. Okay. Right, so we'll get back. I know.
Back button.
Which one? Oh,
Top left. Top left. Right there.
I can get there.
Arrow.
Try that. Okay. Now this form here is just, I hate these. Well, at least there's not a line. Okay, so you have plenty of opportunity there. But this, you know, I hate this form because it encourages people to do things they shouldn't do. All right. About 25 years ago, Jim Pylon is a really good lawyer in Naples, a good friend of mine. I looked at Jim one day and I said, Jim, you know, all those blank lines in the contract and this form, like I said, aren't these folks drafting, practicing law when they're doing that? He looked at me and goes, yeah. And I said, anybody ever worry about that when they draft these forms? So there's something right here. I just, not that you guys, well, first you're not supposed to draft, you know that. But it's not that that's necessarily a horrible thing. It's just that the problem is you guys are salespeople, not wordsmiths. So, you know, try to stay with what you do well and what you don't do well. So anytime you're tempted to write more than 2 or 3 words, I think it's just It's just dangerous no matter how experienced you are. It's like I was talking to somebody the other day. I said, I see all the things that get screwed up and I fix them. I get contacted by title companies to go do lawsuits over things that got screwed up. So even though, and nobody out here has done more closings than me, but I've done more that got screwed up than hopefully you guys will ever see. So I've seen the things that realtors make mistakes on and people make mistakes on, and sometimes they do intentionally. And I still haven't seen everything. I tell you, just about the time, you've heard this probably your whole life, just about the time I think I've seen it all, I see something new, So it happens. Okay, we have an addendum for short sale. I'm not going to go through that. I don't think we have any of those right now in this market. I do have a question for y'all, though. I'm seeing, and I talked to somebody in the clerk's office, and they're shocked as well. We're seeing a step up in condominium lien foreclosures. Have y'all seen that? Have you experienced anything with that? I'm just shocked by that because I'm not aware that any condominiums have gone down in value. So there's got to be some equity in these things. I know there's equity. We're doing a few foreclosures, and there's equity in every single one of them. In fact, huge equity. But anybody, any ideas on that? Not aware it's happening? Okay.
So, Eagle Creek had a couple that I saw that they owed $180,000.
That's,
To Eagle Creek because they owed the assessment and they had reassessed everyone another $80,000 plus it was a golf membership, so it was huge.
yeah, well, you get double dinged in Eagle Creek because of the golf. You have to be a golf member and you have to be the HOA as well. So
my buyer almost bought it, and I took him directly to their office and I said, why don't you talk to them and see everything that is owed before you get involved.
okay, I get that, but the ones I'm looking at are just regular condos. Are not. All right, nobody has the answer to that. Okay, that's all right. So we'll get down here for a second. Just stay with me. Okay, we have an amendment to listing contract for rental changes. I don't think that's going to be a big deal for you. With this form, the amendment to listing contract changes, that again is one of those blank forms that you can change. Remember, an addendum to the sales to any contract is something you're doing while you're putting the contract together and adding to it, kind of like Frankenstein. And an amendment is you already have a contract that's been executed, it's binding, now you're going to change something in it, okay? As a practical matter, if you find a form that's titled an amendment or an addendum, you can use it either way, okay? Because it doesn't really matter what we're doing when we sign it up. Okay, I want to go over this form with you because people ask a lot of times, well, what am I going to do? I've got a condo, I've got a golf membership, I've got a homeowner association, and where do I put how much all this is going to cost somebody? And Fiddler's is a great place to ask that question, right? Because you're going to move in there and you got to write checks like every month to somebody. It's beautiful, but you pay for beauty, right? So you look there, and Pelican Bay is the same way, all right? So we developed a form that says, okay, don't be monkeying around with the homeowner association disclosure form because you put anything on there other than the HOA and it invalidates it. And don't monkey around with the condominium stuff. So here's a form that you can put all of that on. So you fill in the property address, and then we've got a line here for all of these different items. All right, now, if you do this, then you're taking it upon yourself to make sure these numbers are right. Now, the good news is this isn't part of the contract. It's not a required disclosure. So if you feel kind and you want to tell them the golf club costs you this, the homeowner association costs this, the condominium association assessment costs this, here's the total, right? So there's no surprise. Because that's the problem. People say, my buyer moved in and started paying all these expenses and called me and raising Cain saying, why didn't you tell me? Why didn't you tell me all these expenses? It's way more than I thought. We're going to move because, I'm really angry. I have to pay for all these different things, right? Well, here's a place where you can disclose all that. So I just want you to know this does not take the place of the HOA disclosure form. Doesn't take the place of the condominium required disclosure under 718, but it is a place where you can put the golf club, the homeowner association, the condominium association, and whatever else there might be. Okay, so there's a form that we can use. And some people the FAR forms have this, something similar to this. It's attached to the HOA disclosure form. I think it's really a bad idea because I think it encourages people to kind of mix and match and put the numbers on the HOA disclosure. But there's a real worry about the HOA disclosure form because if it's not properly filled out, it's worthless. And it was a real. I was training at NABOR. They were just paranoid about it. I trained at least 3 or 4 times at NABOR over the HOA disclosure form because they were so worried about people doing it wrong. Because it kills the deal sometimes. Okay. Y'all familiar with the transaction forms to go from a single agent to a transaction broker? Do you want me to go over those? Yes, no, maybe.
Probably can become more applicable.
Okay, well, the broker and association disclosure forms, okay, this is the form that if you're in a single agency, this will be the form whereby you're going to disclose, you're going to tell, and what this does, you remember the transaction broker has the least amount of duties to a party. It's more the transaction. That's why it's called transaction broker. So if you're going to transition from a transaction brokerage status into a single agent, or even to a no broker, you're supposed to disclose. And what this does, this form does, is it says, here's what happens if I'm going from transaction to single agent. This is what's going to happen, okay? Okay. So this is disclosure, consent to transaction to transaction broker from single agent. I'm sorry. So this tells them that these are the duties of a transaction broker: dealing honestly and fairly, accounting for all funds, using skill, care, and diligence. And these are straight out of Chapter 475, Florida statutes. These are the duties of a transaction broker: disclosing all known facts materially affect the value, presenting all offers and counteroffers in a timely manner, limited confidentiality. That's a big deal. That's one thing about a transaction broker. You have limited confidentiality. Prevents disclosure that the seller will accept a price less than the asking or listed price, that the buyer will pay a price greater than the price submitted, or the motivation of any party for selling or buying property, that a seller or buyer will agree to financing terms other than those offered, or any other information. Okay. Any additional duties. So limited representation means a buyer or seller is not responsible for the acts of the licensee. So that's transaction brokerage. Okay. Now, the one that I really wanted to go over was the one where you switch from transaction brokerage to single agent. This is single agent. So single agent, we've got pretty much the same things as we did, except now we have not limited, but we have confidentiality duties, obedience, full disclosure, presenting all offers and counters, disclosing all known facts. So single agent, the big difference is the confidentiality and loyalty. The others are pretty much the same. So the confidentiality is a big deal. You have to be completely and full disclosure. So this is single agent. So if you're going to be a single agent, you have to use this. Florida law says if you're going to be anything other than a transaction broker, you have to disclose. So here's the form. You have to get them to sign. It has to be in writing, and the customer has to sign it. So y'all good with that?
Hey, Bill, what are they looking at on that when they see it? Gonna follow what your customer tells you to do?
Well, as long as it's ethical and legal. Okay. It's another way that you could be compensated other than to have a listing. If you're going to work with a buyer, this is an agreement that you have with a buyer that you can get a fee from the buyer. So this says the buyer understands at closing of any property purchased by buyer through broker services, broker may receive some of broker's compensation paid by the listing broker of any such property. But in consideration of brokerage services, it is agreed that at the closing, the buyer through the brokerage service broker, buyer will pay the broker the following sum. Understood and agreed, this broker compensation shall be in addition to any brokerage compensation paid to broker by the listing broker. Okay, everybody understands that? This is a way you can get paid by a buyer in addition to whatever, and it says in addition, okay? Now, we do have an exclusive buyer brokerage agreement. I'm not going to go over that today, but that is something that you should consider as possibly using under the Stinson-Burnett case. Okay, we'll hit a couple more, then we'll be done. Okay, you do have the opportunity to have no brokerage relationship. And anybody have any idea when that might be done?
Why?
Okay, we have a few forms. See if I can pull them up for you. That you can approach a FSBO and say, I've got a buyer that I think is interested in your property. Now, if you have a buyer brokerage agreement, you're going to make this disclosure, you're not going to have any brokerage relationship. Or you go to the seller and you go, look, I'm going to have you sign an agreement under which you'll pay me some amount of money if I bring you a ready, willing, able buyer and buys your property. You have a buyer that's interested, but I'm not going to have a brokerage relationship with you in any way. You may have entered a brokerage relationship with a buyer and you're a single agent. Okay, so you go to the FSBO and you want to make it clear you have no relationship whatsoever. And if this is the relationship, you require to have it signed. Remember, anything other than a transaction brokerage relationship, you need to have the disclosure and it needs to be signed. So if you have no brokerage relationship, you still have to deal honestly and fairly, disclose all known facts materially affecting the value of the property that are not readily observable to the buyer, and accounting for all funds entrusted to the licensee. Okay? Could be the opposite. You might have a listing, you're a single agent, you have a listing, and you're the buyer that comes in, and you're not going to have any brokerage relationship with the buyer because you can't, because you're a single agent for the seller. And that's your business model. Okay? Any other questions about anything? Okay, again, here's another form. You've got a FSBO, and you want to arrange an agreement under which you have somebody you want to show the property to, and you want to try to get paid something from the owner. The owner isn't real keen on listing the property. That's why it's a FSBO. So we've got the seller name, the broker name. We've got a line to put the property. Seller allows the broker to show and market the property and attempt to procure for seller a buyer on terms satisfactory to the seller. Seller acknowledges receipt from the broker of the notice of no brokerage relationship. If broker procures a buyer with whom a seller within blank calendar days enters a contract, then pay the broker percentage of the purchase price. Seller and broker agree, understand, broker does not represent seller in any capacity. Okay. Any deposits paid by a buyer retained by the seller, half goes to the broker not to exceed the broker's compensation. If the transaction does not close because of the refusal or failure or inability of seller to perform, or if seller fails to perform, then the contract at this purchase price or for another purchase price acceptable to seller then the full compensation to the broker is due. The event seller fails or refuses to pay the compensation after demand, seller hereby grants broker the right to place a lien on the property. Okay, we have that in a listing contract too. I think I went through that without mentioning that. It's in the listing agreement. If you don't have that, you can't get a lien on residential property. Under Commercial Property Act, you have an automatic lien. You have to just record it. This allows you to record a lien. So if your seller's backing out of something, you can actually record a lien. And that's a lien against the property just like any other lien. It could be enforced by a lawsuit, or you can leave it out there for a while until the seller tries to sell somebody else, and then they've got to deal with the lien. Okay. Caution note regarding audio and video surveillance recording devices. That's just favorite. Federal and Florida laws governing use of such devices. Many consent of all parties. Such surveillance is required. Okay. If you have it posted that they're there, the fact that they come into the property is consent. Okay. Connection with any litigation, prevailing party entitled to reasonable attorney's fees, and that's the same reason there. Who's going to be filing a lawsuit under this agreement? It won't be the property owner, right? It'd be the broker. So that benefits the broker. Okay, I'm going to go through this one with you. It's not a happy one, but it does happen sometimes. Termination of listing contract. So this is the MLS. It says right here that this is the form right here that terminates listing contract effective a certain date. Now, by mutual agreement, will promptly terminate property in the MLS. So this is important to look at. Listing contract date at a certain date by the parties related to the property is terminated. By mutual agreement, the property will terminate in property in MLS. So this terminates the listing. What does that mean? That means it's ended as of whatever the date this is, correct? Now, if the buyer, if you've got the protection period in there, whatever time period you put in there, if the buyer and seller then go ahead and enter a deal, and more often than not, when the seller wants to terminate a listing, it's because the seller has a buyer. As long as you've put a sufficient time frame in that listing contract, you still have the right to be paid, okay? Now, to point out, we do have the residential vacant land, so that we do have the, I went over the listing contract for improved property. The vacant land contract is the same. We just took out the parts that have nothing to do with dirt. One other form I want to go over is, give me 1 second. So here, I'll show you this one. Remember the code compliance brochure we talked about earlier? Okay, this is that code compliance form. And it basically just says that everybody has the right, should have their property inspected, both a seller and a buyer. And under our agreement with the county, we're supposed to give those, you are supposed to give those to sellers and buyers at first contact. This is a form. People say, how do I get how do I get a hold of the CDDs? So we've got this form, CDD MSTU worksheet. These are all the CDDs that we're aware of about 2 years ago. We put the form together. So if you're looking to get a hold of them, I've been here a while. When I was first down here, working with anybody with a CDD was really difficult. They were uncooperative on a good day and not cooperative at all on a bad day. but the industry has morphed into a service industry, and these folks tend to do a pretty good job now of being responsive and providing information. So the time that you'll need to contact these folks is when you've got a CDD or a CDD involved. The MSTUs are all run through the county, so you just get a hold of the county finance department. But the CDDs, those are privately run, as I explained during the contract class. The funds to pay the CDDs are collected by the tax collector, and they're sent on to the CDD. So I suspect the tax collector gets a little piece of whatever it is for collecting them and then sends it on. So these over here are everybody, all the contact information we had for all the different ones that are here and in Lee County. Okay, and these are all the MSTUs, MSTBs. No contact because I told you those go through the county finance department. Okay, but at least here you ought to be able to find out. And they do change once in a while, but not frequently. So when they do change, if you got a hold of one of these folks, now I'm happy to tell you under the way it works now, they will tell you who the new servicer is for that CDD, so you'll be able to track down the information. That's important because on the CDD form, as you fill out, which is disclosure form, there's 2 blanks to fill in. One is the principal, the remaining unpaid principal portion of whatever it might be. So go to Fiddlers and talk about that. I don't know what they look like these days, but you know they floated tax-free bonds to put in the roads, put in the sewer, put in the electric, put in the lights, put all that infrastructure out there, and I think they're still paying that off. So that's a principal component. And then every year they got to take care of that stuff. They got to put new light bulbs in. They got to repave the road. They got to fix anything that's broken. And that's an operating expense. So there's 2 components to that. And so you check. This is where you can go to find out what the remaining unpaid principal component is, and that goes in the 1 blank. And then the annual operating expenses, those are also, you can get that from these folks too. But that's on the tax bill has a lump for that, what goes to the CDD, and part of that is, in some cases, principal capital, part of it is operating expenses, okay? The older ones, like in Lely, I think the Lely one is about paid off, so all they've got there right now, only half of Lely has one, and I think they're down to only operating expenses now, or pretty close to it. Key Marco has one too. I think they're getting excited about doing stuff out there. They're maybe getting some new principal components. Okay, here it is. Remember the loan I couldn't remember the name of? It's a PACE loan. It's secured as a lien against the property collected through the tax collector's office. I think Collier County said they weren't going to allow those anymore, and then I think the legislation was passed that says you have to have them, and those are really a mess to pay off. There are more of those out in the Immokalee area than there are down in this area, but they're a long-term way to finance home improvement or something to protect against hurricanes. So if you want to put a new air conditioner in your home, for example, you could get a PACE loan to do that. And they're paid over a long period of time, and they're collected again by the tax collector, and that goes to pay off that loan. So when we have those, we don't have too many of them down here in our market, but when we do have them, they're really difficult to get payoffs, coordinate them, because the payoff arrangement's an annual thing. It's not as simple as figuring out what it is, going in and seeing what the tax bill is, doing all that. So just want you to know that those exist, and they're PACE loans, so we do have to get those out there. They'll show up in the title search, but that's the disclosure form from your seller. So I don't think any of your sellers are going to have a PACE loan. If you get out in Golden Gate and start moving up in some of those areas, they might. We don't have, I think the last time I checked, there was like 40 something in the whole county. So that number probably is not current right now, but we don't have a lot of those. But other parts of the state, there was a bunch. And I think part of the problem with them was these guys would sell the energy efficiency home improvement with a PACE loan concept, saying it's like, you know, only costs you a few dollars a month. It's like that company that was getting those arrangements where they give you $5,000 and they have the right that you pay them a commission, you sell your property the next 40 years, and they were taken to court. So PACE loans, I think, are sold the same way because it's going to pay them over 20 or 30 years, but they end up being liens against the property through the tax office, and that's not necessarily a good thing for your sellers. Anybody have any questions about anything? If not, I'll call it a day. Let you guys go out and start earning a living again. Thank you for being here today.
Thank you.